My name is Ian SEIDERMAN. I'm the senior of the International Commission of Jurists, and I'll be moderating the first part of this session. I'm sorry. Okay. Didn't have the microphone on. Just to repeat, I'm Ian SEIDERMAN. I am the Senior Legal and Policy Director of the International Commission of Jurists, and I'll be moderating the first part of this afternoon session on ensuring international accountability for perpetrators of enforced disappearance. Before beginning, I've been asked to repeat to everyone the code of conduct that is governing this conference. Just a brief reminder, I'll read it very quickly. To ensure a respectful and constructive discussion, we ask all speakers to adhere to the following guidelines. We agree to disagree, no inflammatory language, one intervention at a time, stay on topic. Panels are not meant as a platform to deliver political statements, adhere to time limits, and respect the moderator's role and collaborate if asked to moderate language or conclude. So thank you for your cooperation on those. I'm going to be very brief in my comments. I think we'll have to somewhat truncate the originally scheduled length of this session due to the fact that the morning session went somewhat overtime. But I'll just start by saying that a distinguishing feature of enforced disappearances is that it's one of the very few human rights violations that we can unequivocally characterize as a crime under international law. What this means, of course, is that a core part of the state's protective obligations is to ensure accountability for acts of enforced disappearance. In other words, to promptly, thoroughly, impartially, and effectively investigate allegations and to bring suspected perpetrators to justice. As a matter of general international law, this also means that both the responsibility of the state and the criminal responsibility of individual perpetrators is engaged. While enforced disappearances may be prosecuted as a crime against humanity, where they form constituent acts in a widespread or systematic attack on a civilian population, for instance, under the Rome Statute of the ICC, even a single act of enforced disappearance engages the responsibility of the state to prosecute under the Convention on Enforced Disappearances. Enforced disappearances have and continue to be addressed by both domestic courts and international tribunals and mechanisms, but the processes have met numerous challenges and impunity remains the norm rather than the exception around the world. This afternoon's panelists will touch on a few of the challenges. So as I mentioned, we will divide the session into two separate panels. The first will look somewhat at past efforts, and the second will look at new and emerging issues, but it's not completely cut and dried. There'll be some overlap between the two, as speakers may address prospective and retrospective aspects. So on this first panel, there are four distinguished speakers. Deputy Prosecutor Nazat Shamim Khan of the International Criminal Court has been unable to join us now in person, but has kindly sent a video address, which we'll hear in a minute. To my left, Ward FERDINANDUSSE is a Deputy Specialist Prosecutor at the Kosovo Specialist Prosecutor's Office. Reed BRODY, to my right, a Commissioner of the International Commission of Jurists. And to my far left, Anna Sroven-Korali of the International Law Department of the Geneva Graduate Institute. And I will introduce them further before they speak. We'll hear the video first, but I'll introduce the Deputy Prosecutor Khan. She is from Fiji. She studied law in the UK and was called to the Bar of England and Wales and the High Court of Fiji. was appointed Fiji's Director of Public Prosecutions in 1994, and in 1999 she was appointed Fiji's first woman High Court judge. She subsequently opened her own legal practice, including working on human rights. And in 2014, she was appointed Fiji's ambassador to the UN in Geneva and Vienna. In 2021, she was elected president of the Human Rights Council. And in December 2021, she was elected the deputy prosecutor of the International Criminal Court, which is the position she presently holds. She will address the ICC's approach to enforce disappearances under the Rome Statute and in practical application, also contrasting this with that of the Convention and other international tribunals. So I hope the video is ready and we can start.
Excellencies, distinguished delegates, ladies and gentlemen, good afternoon to you all. It gives me great pleasure to participate at this first World Congress on enforced disappearances, and especially on this panel discussion on existing avenues for seeking accountability alongside my fellow distinguished panelists. The Convention for the Protection of All Persons from Enforced Disappearances provides a definition of the crime of enforced disappearance and compels state parties to take the necessary state action in order to both prevent the occurrence of the crime and to allow for the investigation and prosecution of the perpetrators. This is an important instrument for so many reasons, including that it binds state parties to make enforced disappearance criminal under their national law, and it recalls the right of every person not to be subject to it, even under exceptional circumstances such as the state of war or threat of war, internal political instability, or any other public emergency. The Convention also guarantees the rights of victims or their relatives to have access to justice and full and effective reparation. Importantly, it establishes the Committee on Enforced Disappearances, whose work for over more than a decade has been tremendously valuable. The Rome Statute recognizes enforced disappearance as a crime against humanity. Articles 7.1.1 and 2.1 define the crime as 1. The arrest, detention, or abduction of persons by or with the authorization, support, or acquiescence of a state or a political organization, followed by 2. A refusal to acknowledge that deprivation of freedom or to give information on the fate or whereabouts of those persons with the intention of removing them from the protection of the law for a prolonged period of time. The Convention on Enforced Disappearance and the Rome Statute are complementary legal frameworks aimed at addressing the grave violation of enforced disappearances. However, there are interesting distinctions. While the Convention focuses on state obligations, prevention, and victims' rights, the Rome Statute targets individual perpetrators through international criminal accountability. In this respect, the International Criminal Court, Office of the Prosecutor, prosecutes individuals responsible for enforced disappearances when they are part of a widespread or systematic attack against a civilian population. The distinction highlights that the Convention on Enforced Disappearance emphasizes preventative measures, combating impunity and ensuring the rights of victims to justice and reparation at the national level, while the Rome Statute addresses the most egregious cases through international prosecutions. Another interesting distinction that makes the Rome Statute more demanding and different from the definition in the Convention on Enforced Disappearance is that the Rome Statute specifically requires as a mental element of the crime that the perpetrator intended to remove the person from the protection of the law for a prolonged period of time. There is to date limited ICC case law interpreting this specific requirement of intent as a mental element of the crime. However, prior to the opening of an investigation into the situation in the Republic of Burundi, the Office of the Prosecutor made an application to the court, pursuant to Article 15 of the Rome Statute, for an authorization of this investigation. In its application to the court, elements of enforced disappearances were raised. In October 2017, Pretrial Chamber 3 authorized the prosecutor's request to open an investigation in Burundi. In its decision, the pretrial chamber found a reasonable basis to believe that as part of a widespread and systematic attack targeting political opponents, demonstrators, human rights activists, journalists, members of the political opposition, and others, victims were subjected to murder, imprisonment, torture, rape, enforced disappearance, and persecution on political grounds as crimes against humanity. When looking at the element of intent, the pretrial chamber stated that it is often possible to infer the perpetrator's intention from the manner in which liberty is deprived. In addressing this point, the chamber held that the removal of the victim from the protection of the law, such as the absence of a court order for detention, abduction in cars without license plates and with tinted windows, detention in secret, unofficial prisons, non-registration of names of the detainees in official records, or capture in desolate areas were indicative of intention. Moreover, the same decision held that a period of several months or years certainly fulfills the requirement that the intended removal be for a prolonged period of time. The same chamber made several other interesting findings with regards to the crime of enforced disappearance. It held that the crime consists of two interrelated components. One, the victim's deprivation of liberty, and two, the ensuing denial or suppression of information. With regard to the first component, the chamber understood the terms arrest, detention, or abduction to cover comprehensively any form of deprivation of liberty of a person against his or her will. The crime also includes the scenario in which a victim, initially arrested and detained lawfully, may be disappeared while in custody. With regard to the second component, the chamber held that the refusal to acknowledge or give information encompasses outright denial or the giving of false information about the fate or whereabouts of the victim. Whether or not the victim's family lodges a formal complaint, the state authorities are duty-bound to commence an impartial and thorough investigation ex officio, without delay, into the disappearance of the victim. The chamber also held that the crime of enforced disappearance is considered a continuous crime, as long as the perpetrators continue to conceal the fate and whereabouts of the person or persons who have disappeared, and these facts remain unclarified. The more demanding definition of enforced disappearance in the Rome Statute also sets the ICC apart from other international criminal jurisdictions, such as the extraordinary chambers in the courts of Cambodia and the Kosovo specialist chambers, whose legal framework did not require proving a specific intent nor a particular duration for the deprivation of liberty. The Rome Statute definition therefore makes it potentially more challenging to prosecute the crime at the ICC. Whether in the future there are attempts to align the definition with the Convention definition will of course be a matter for states parties of the ICC to consider. Other challenges of course arise from the complex nature of investigating and prosecuting enforced disappearances under the Rome Statute. Gathering the requisite evidence for the crime of enforced disappearance is a particular challenge because of the very nature of this crime, which often involves secretive actions, making it difficult to gather concrete evidence. Victims are typically hidden or kept incommunicado, and perpetrators often take steps to cover their tracks, such as falsifying records or coercing witnesses into silence. In addition to this challenge is the need for state cooperation for investigations. If states are unwilling to cooperate, this hinders access to key information and can prevent a thorough investigation. As I mentioned earlier, the mental element required for the crime under the Rome Statute can also be difficult to prove. Demonstrating this intent requires a deep understanding of the perpetrator's motives and actions, which may not always be apparent or easy to establish in court. In some instances, perpetrators of enforced disappearances may be powerful political or military figures who enjoy domestic legal impunity or political protection. This can create barriers to prosecution, especially in cases where local legal systems are unwilling or unable to hold such persons accountable. Despite these challenges, the Office of the Prosecutor remains committed to its mandate under the Rome Statute. When investigating situations, we find that enforced disappearance is part of a broader pattern of human rights abuses, such as systematic torture or political repression. Therefore, the Office is careful in ensuring that it is not overlooked in its connection to larger structures of violence. In addition to this, the Office is conscious of the fact that enforced disappearances may disproportionately affect individuals based on their gender. We have learned so much over time from the experience in parts of Latin America, where for decades so many men were targeted for disappearance by totalitarian regimes due to their work as union leaders or because of their political opinions and activities. Yet it is also the case that women can be specifically targeted for disappearance in certain contexts. Take, for example, the abductions of women in Ciudad Juarez, Mexico, or even the kidnapping of young girls by Boko Haram in Nigeria. And what about the gendered impacts of forced disappearance? When men are disappeared, how do their mothers, wives, and daughters suffer in order to find and access them? When a woman is disappeared, how might her family be affected? What fears and stigma may arise in her absence? Sometimes women and men are forcibly disappeared in the same ways, and for the same reasons. Sometimes the motivations, methods, and impacts of disappearance may differ based on gender. And clearly, we must also be alert to the specific experiences of children when we address enforced disappearance. How are they directly or indirectly impacted? To detect and understand these nuances, we must look not only at our statute, but at the social and political context of where we work. This requires humility, and it requires diligence. Yet these are the stories, the lived experiences that need to be heard through the justice system. The Office's policy on gender-based crimes and our policy on children are useful tools for identifying relevant patterns in our investigations and ensuring that gender and child-specific impacts are examined throughout the investigation and prosecution process. These areas remain a priority for the Office of the Prosecutor. In conclusion, the reality of the crime of enforced disappearance is that it is a continuing crime, so long as the fate and whereabouts of the person have not been clarified. The Rome Statute ensures that such crimes are therefore not subject to statutes of limitation. This is important because it reinforces the importance of accountability at the international level. We cannot emphasize enough the importance of acknowledging that enforced disappearance remains a global phenomenon and requires a global effort. The Office's understanding of its important responsibility to ensure accountability is informed by this reality. We will not be deterred in our efforts to bring justice to victims, and we count on the continued cooperation with states in our investigations. I thank you.
Well, thank you, Deputy Prosecutor Khan, if you are watching online, for this extremely informative and rich presentation on the ICC's work. Next, I'll turn to the Deputy Specialist Prosecutor at the Kosovo Specialist Prosecutor's Office, Ward FERDINANDUSSE. I won't, in the interest of time, read the full impressive biography, but just to indicate that he has taught international and European criminal law at the University of Groningen, and was prosecutor at the Dutch National Public Prosecutor's Office in Rotterdam, working on a wide variety of cases that are relevant here. So without further explanation, I will turn it over to you, please.
Thank you. And I thank the organizers for the invitation to participate today. In the next 9 minutes or so, I will briefly introduce the Specialist Prosecutor's Office for Kosovo and its mandate, the problem of enforced disappearances in Kosovo, and our case law to date. And I will conclude by showing you a short example of witness testimony regarding enforced disappearances in our courtroom at the Kosovo Specialist Chambers. If we go to the next slide, you'll see that the Kosovo Specialist Chambers and the Specialist Prosecutor's Office for Kosovo are temporary institutions with a specific mandate. They were established following adoption of a constitutional amendment and the law on the They are part of the judicial system of Kosovo, but based in The Hague, the Netherlands, on the basis of a host state agreement between the Netherlands and Kosovo. And what we do at the KSC and the SPO is mainly prosecuting war crimes and crimes against humanity under customary international law. Our temporal mandate covers the 3-year period between the beginning of 1998 and the end of the year 2000. And the SPO specifically has the authority, among other things, to question suspects, victims and witnesses, collect and examine information and evidence, and take decisions on the initiation of criminal proceedings. Turning to the next slide, we turn to enforced disappearances in Kosovo. In Kosovo, more than 6,000 tracing requests were submitted to the International Committee of the Red Cross for the period between 1998 and 2000. And the ICMP estimates that the total number of missing persons from the Kosovo conflict is approximately 4,500. In a report from 2009, Amnesty International estimated that many thousands of these were the victims of enforced disappearances in the legal sense of the term. According to the ICRC, which maintains a book of the missing in Kosovo, more than 1,600 persons were still missing from the Kosovo conflict on the day of the disappeared, that is 30 August last year. And enforced disappearances featured in all ICTY war crimes trials in relation to Kosovo, including those of Milosevic, Milutinovic and others, Djordjevic, as well as Haradinaj and Limaj. While the crime of enforced disappearance did not feature in the statute of the ICTY, the statute did grant the ICTY jurisdiction over the constituent acts of enforced disappearance. And those indicted in relation to enforced disappearances were charged with war crimes or crimes against humanity. I now turn to the law and practice of the KSC and the SPO. As you can see on this slide, if you have good eyes, the law on the Specialist Chambers and the SPO covers the crime of enforced disappearance of persons as a distinct crime against humanity in Article 13(1)(I), pretty much on the bottom of your screen. And we have charged the crime of enforced disappearance as a distinct crime in one ongoing trial at the KSC. This is the trial of former Kosovo President Hashim Thaçi and 3 co-accused who were all former leaders of the Kosovo Liberation Army, the KLA. They are charged with 6 counts of crimes against humanity, including enforced disappearance of persons, and 4 counts of war crimes. The trial began in April 2023, and to date, evidence from some 180 witnesses has been presented to the court, including from more than 100 witnesses who appeared in person in the courtroom. And we expect to conclude the SPO's presentation of evidence, in this case, in April of this year. We're in the last months. In total, there are 20 victims of enforced disappearances in 7 different locations in this indictment that we are prosecuting now. And on the Not yet. If you click to the next one, you can see one page. Yes, of a list of victims of enforced disappearance in this indictment. Listing municipality, related location, date of disappearance and known victims. On this slide, you can see those locations in Kosovo of the enforced disappearances we have charged, and you can see that they're spread out over the country. As we are still in trial, no judgment has yet been passed. However, our proceedings have so far yielded some relevant case law. In response to preliminary motions, both the pre-trial judge and the Court of Appeals concluded that enforced disappearance of persons was a separate crime against humanity under customary international law by 1998 at the latest, as you can see on this slide. And on the next slide, you'll see that in the confirmation of the indictment, the court concluded that the definition of enforced disappearance under customary international law does not establish a minimum period for the victim's removal from the protection of the law. What our practice so far has also yielded is a vivid illustration of the importance of prosecuting enforced disappearances for surviving victims. And I will end my short contribution today by showing you two clips of one witness who testified in our court in 2023, the first year of our trial, because better than I can express, they illustrate what can be the importance of charging enforced disappearances where the evidence allows for those who are left behind. This witness, Ms. Bozanic, told the court about the disappearance of her husband and son, who were taken during an attack on her village in July 1998. And in this first clip, she described to the court the impact on her life.
Mog sina kad su odveli od moje ruke, to je nešto što izgubiš pola srca, a pola ostalo mi za drugu porodicu. I tako se nosim. I umreću sa time i poneću taj misao na posljednji dah za mog sina i suprugu. I kao što sam rekla, idem na kraj sveta, a samo zbog istine.
And in the second video, to be sure,
Sina kad su
yeah, if you click to the next slide, then we can stop the loop. In the second video, Ms. Bozanic also describes what it meant for her to testify about her missing loved ones in court so many years after they disappeared.
Mog sina kad su odveli od moje ruke.
Now you need to please click to the next one.
Mog sina kad su odveli od moje ruke. Hvala i vama. Ja sam ovu željela da dođem do ovde. I dok sam živa, i ne dok sam živa, ali dokle god mogu, ja ne odustajem od moje istine i samo istine. Ići ću i dalje, gde god me pozovu, ja stati neću. Umreću sa moj bol i moju ranu na srce. Hvala vama puno što ste me pozvali. Ova želja mi je bila mnogo važna i ova želja mi je ispunjena kao da sam videla mog sina i mog supruga i sve ostalo. Iako sam zadovoljna sa vaše strane što sam imala priliku da dođem ovdje. Još ovdje mi je bilo grižu savesti da dođem. Hvala puno do neba. To je moja želja.
Thank you very much, and we wish you well in your...
Hvala i vama.
Thank you. I thank you for your attention, and I look forward to exchange questions and ideas with you.
Thank you so much, Ward, for explaining a tribunal that doesn't get probably as much attention as it should, and especially for those clips with the vivid witness testimony, which I think added an extra texture. I'm going to turn now to my right to Reed. Reed is a commissioner of the ICJ who has made a career of helping victims pursue abusive leaders such as Augusto Pinochet of Chile, Hissène Habré of Chad, Jean-Claude Duvalier of Haiti, and Yahya Jammeh of Gambia. I won't read his full biography either, but I'll mention importantly that he played a major role back in 1992 with the ICJ on the development of the Declaration on Enforced Disappearances, which preceded the convention, of course. So, Reed, over to you to account your experiences in more detail.
Thank you very much, Ian. Thank you, everybody. I did want to talk about 3 of those cases in which enforced disappearances played a major role, either legally or politically, as a hook in prosecutions. As Ian mentioned, I was involved in the early days in the drafting of the Declaration. And one of the key points about enforced disappearances that was included there and has been included since, as the deputy prosecutor mentioned a few moments ago, is that disappearances are a continuing crime. And as the Working Group on Enforced Disappearances said in a comment, that means that it's possible to convict someone for enforced disappearances on the basis of a legal instrument that was enacted after the disappearance began without violating the non-retroactive principle. And disappearances continue until the whereabouts of the person have been accounted for. And the first case in which that really hit home to me was in the Pinochet case. As you all know, in 1998, Augusto Pinochet of Chile was arrested in London on a warrant from a Spanish judge. Federico Andreu, who is in the audience from Amnesty International, played a very important role in that. Pinochet had given up power in Chile, but he remained immune from justice for a number of reasons, and one of them was because in 1978, 5 years after his coup, the military passed a self-amnesty that basically shielded crimes that had been committed for the first 5 years during the height of that repression. And so Chilean victims went to Spain. They filed cases in Spain. When the Spanish judge found out that Pinochet was in London, he issued an arrest warrant. Pinochet challenged his arrest. He said, "You can't arrest or extradite me. I have immunity as a former head of state." And we participated together with Amnesty I was at Human Rights Watch then, in the legal proceedings. And one of the members of our team was a Chilean lawyer who had been the head of the Vicaria of Solidarity under the Catholic Church's legal office under Pinochet. His name was Roberto Garraton. And he said, "You know, Reed, when Pinochet was disappearing people, I used to file habeas corpus, but you know how many habeas corpus petitions I filed?" I said, "No, Roberto." He said, 1,001, I forget the number, 1,198. "You know how many succeeded?" "No, Roberto, 0. And I would ask myself, why am I doing that? But today, with Pinochet in house arrest in London with these proceedings, I understand why I did that work. As you know, the House of Lords issued 3 decisions on the Pinochet case. The final decision said that Pinochet lost his immunity only when all 3 countries involved, Spain, Chile, and the United Kingdom, had ratified the Convention Against Torture. And it turned out that that date occurred almost at the very end of Pinochet's rule. And in fact, of all of the cases of torture that had been presented to the British courts, there was only one case left. And it seemed like the extradition was hanging by a string. And then the Spanish judge fed the dossier with the thousands of cases of disappearances that had occurred. And the extradition court, in a very important ruling, said, well, in fact, these cases, first of all, it was the first judicial recognition that disappearances can be a form of torture for the loved ones, as we've been hearing today, and as many of you know firsthand, and also that they are continuing crimes. And so they continue after the date that all three countries had ratified the Torture Convention. Now, as you also know, General Pinochet ultimately was sent back to Chile on supposed health grounds. But what was very interesting was by that time, Chilean judiciary looked at what was going on in the United Kingdom and said, we can do that too. And when Pinochet returned to Chile, that self-amnesty that he applied, that the military had granted itself in 1978, was found not to bar cases of forced disappearances that were ongoing. And so by the time Pinochet died, there were a number of cases against him. He was under house arrest. And in fact, hundreds of members of the security forces were convicted in Chile for crimes that were seemingly barred by the 1978 amnesty because of the principle of continuing crime. When the House of Lords ruled that Pinochet did not have immunity, I think there are a bunch of us here who are old enough to remember that. It was a champagne moment in the human rights movement. All of a sudden, we realized that we had an instrument in universal jurisdiction and international justice to bring to book people who seemed out of the reach of justice. And I was approached, we had all these meetings with the FIDH, and who's next? And we were approached by Chadian victims who said, we have a former dictator, Hissène Habré, who's in jail, who is now in exile in Senegal, and he's committed even more crimes than Pinochet. And among those crimes, there were many, many disappearances. Hissène Habré had clandestine prisons. There was a man who was in his prison, Suleiman Gengeng, who, as people were dying around him, took an oath that if he ever got out, he would fight for justice. And when he got out, he started documenting these crimes, and including over 100 cases that he documented of enforced disappearances. And so we brought a case with the victims in Senegal. I won't describe the 18 years it took to get to court. But at a certain point, the Committee Against Torture and ruled that Senegal had to extradite or prosecute and had to change its laws to allow both retroactive application of international jurisdiction and to incorporate the core crimes. Senegal did that. Hissène Habré then got a decision from the ECOWAS Court of Justice saying, you can't try him retroactively before Senegalese courts. You need to set up an ad hoc tribunal. And the African Union then actually set up an ad hoc tribunal, which included crimes against, included enforced disappearances as a crime against humanity. And Hissène Habré was prosecuted and convicted for crimes against humanity, for enforced disappearances. As part of crime against humanity. Among the other groups that wanted to do what the Chilean victims had done in the Pinochet case were Gambians, and we heard this morning a very powerful presentation by my sister Aisha Jammeh. I don't know if she's there, about the disappearance of her father. Actually, what we discovered was that the worst crime committed during the worst single crime committed during Yahya Jammeh's period was 59 West African migrants from 6 different countries who were trying to get to Europe were beached in Senegal, or beached in Gambia, were arrested, and were all, except for one, were killed or disappeared. 44 of those were from Ghana. And so this became for us a way to involve other countries in the search for justice. And with Aisha, we met actually with the president of Ghana, Nana Akufo-Addo, who was actually the foreign minister at the time that this happened. These people were, it turns out that one man survived this massacre, a Ghanaian man named Martin Cherry, who jumped out of the truck before the others were all killed. And he actually made it his life's work to find out the truth. And he went from village to village in Ghana. He knew that Kofi came from this village, that Kojo came from that village, and he actually went and alerted the families. And then we, Human Rights Watch and Trial International, did a report showing that these people were actually killed and disappeared by Yahya Jammeh's junglers, his hit squad. But this case of West Africans, including from Ghana, from Nigeria, from Cote d'Ivoire, from Togo, from Senegal, became the hook to get a regional interest in the case. And as Aisha mentioned this morning, a few weeks ago, Gambia and ECOWAS created the statute of a new hybrid tribunal, the Special Tribunal for Gambia, that will investigate and prosecute crimes committed in the Yahya Jammeh era. And the hook for getting ECOWAS was all these people from other countries who had been disappeared. And the statute specifically puts in enforced disappearances as a crime against humanity. And also, interestingly, because of that case, it says that the court has jurisdiction over crimes committed in the territory of Gambia, which shall include crimes partly committed in the Gambia, because many of those people were actually killed and dumped in Senegal. Which Yahya Jammeh used a part of Casamance as like his personal cemetery. So I'll finish up. Just important things to take away. Continuing crimes with a hybrid tribunal, I didn't get into that, but you can do anything you want. Once you have jurisdiction, you can put anything in the statutes of a hybrid tribunal. And third, you need to be creative about these things. Thank you.
Thank you very much, Reed. That was very informative, and sorry to cut you off. We're under these extra time pressures, unfortunately. So now I'll turn to Anna Corali, who is an international lawyer specializing in criminal law, writing a doctoral thesis on the crime of enforced disappearance. And Anna, I will turn it over to you to discuss. I think you've looked at 100 or so domestic cases of enforced disappearances, and you're going to talk about challenges where the state has no offense in their domestic legislation. So please, over to you.
So somehow, without coordinating, we managed to coordinate with the other panelists, because Reed really made the perfect introduction, if you like, into what I'm going to say right now. So I'm going to focus on one key challenge that has somehow existed in most cases on enforced disappearances that have been carried out worldwide until now. And as you rightly said, I did look in around 150 cases, domestic cases on enforced disappearances. Some of them are not necessarily labeled enforced disappearance. Very often they are labeled unlawful deprivation of liberty, abduction, kidnapping, aggravated unlawful deprivation of liberty, torture, homicide, and so on. I've also looked into all existing hybrid and international criminal law cases, but I find somehow the domestic ones more interesting, and I also think that the future is in domestic courts. Therefore, I'm really going to focus on the key challenge before domestic courts, which was actually the principle of non-retroactivity and how to somehow deal with the fact that enforced disappearance is a domestic crime. Now, again, what I'm going to tell you today is based on the case law of mostly Latin American countries, simply because the most jurisprudence comes from there, especially Argentina, Colombia, Uruguay, Chile, Peru, Mexico a bit also in the past years, El Salvador, but also many other countries, including Zimbabwe, the Philippines, Pakistan, Spain, even Germany, Switzerland, as we see it here, Italy. So there is quite some case law which can help us to improve future, hopefully, investigations and the prosecutions of enforced disappearances. Now, my really main goal today is for you to leave this room understanding why it's so important to criminalize and to investigate enforced disappearance, and of course also to prosecute and punish them under this specific label. So, as already Reid very well described, and Ward as well, enforced disappearance is a continuing crime. Now, what this means? This means that you actually have indeed the possibility, according at least to some courts, that you apply a law which came into force later than the actually perpetrator acted. Still,
Is it working?
there is a, okay, now
Okay,
it works.
got
Okay. So again, as we said, it comes again with enforced disappearance, showing that the definition requires a state involvement. This comes with the fact that in most cases, when the domestic courts take action, it's only after some decades or some years when there is a change of regime. And this is when comes a moment when they can actually punish these heinous crimes. And what the courts did when they were faced with concerns regarding the prohibition on non-retroactivity, was the following. I've somehow divided groups of states into, if you like, the creative and the non-creative states. So the non-creative states, which were many, they basically simply turn to these alternative offenses, so usually unlawful deprivation of liberty and so on, what I've said at the beginning. Now, why is this problematic? Well, first of all, because obviously they don't denote the gravity of the crime, but I think much more importantly, because it comes with various legal consequences. And I'll just give you a flavor of what I have in mind. Well, the first obvious difference is in these ordinary crimes, it's regarding the penalty, because usually unlawful deprivation of liberty would come with significant lower penalty than enforced disappearance. Another example would be concerning the extradition, because a state, even nowadays, if it has ratified the International Convention, could say, well, you're asking me to extradite enforced disappearance, but what the case that I have here at hand is not enforced disappearance. So here again, you see a huge difference. Another example is related also to the modes on responsibility. I'm not going to go into depth here, but you can again reach significantly different definitions. There have been actually sentences, including in Germany, where the courts were faced with this question, and simply by the fact that they didn't consider the crime as continuing, they couldn't basically convict defendants as the main perpetrators of enforced disappearances. Now, so as I said, these were the non-creative countries. Then you had one country, which was Colombia, which was kind of middle between non-creative and creative, which what they tended to do was to combine two different offenses. So they would take the unlawful deprivation of liberty, they would apply it from the moment when the perpetrator acted until the moment when the enforced disappearance was criminalized in the country, and that from that moment onward, they would apply enforced disappearance. Do we like this result? I think we like it better than the first one, but I think this result is actually problematic from the perspective of the defendant, right? Because we are actually applying two criminal definitions to the same conduct, which usually, according to some of the basic domestic criminal law principles, such as principle of alternativity in specific, wouldn't be possible. Now let's turn to the to the countries that are the biggest interest for us, which are the countries that they actually try to apply the definition of enforced disappearance retroactively. And one of them was, for instance, of course, also the case of Hissène Habré, which you mentioned, which how they went about it was to say that enforced disappearance was actually already criminalized under international law at the time when it was committed. Other countries, they would simply say it was a general principle of law, therefore we can somehow flexibilize this principle of legality that we have to deal with. You also have some countries, such as Uruguay, in some cases where they would actually simply say, oh, it was an international crime, hence we don't have to apply the principle of non-retroactivity at all. And then finally, you have some countries which they actually said, this is a continuing crime, meaning that it's ongoing until the fate or whereabouts is determined. Hence, we can apply the new law, which is in force at the time being. But even here, you have, again, different position of countries on what they considered as the fate or whereabouts that being determined. So you have some states which would say this objectively means objective the end of the crime, objective identification of mortal remains and then identity. You have others which would say this would be until the moment when the perpetrators don't anymore conceal the fact or whereabouts. This was, for instance, the case, if some of you are familiar with the judgment from Belgium regarding enforced disappearances in Guatemala in 23, because this was the definition of enforced disappearance in Belgium. Where I'm taking you with all this, I'm just trying to emphasize that it's really fundamental to be able to deal with this crime nowadays in most countries around the globe, to have actually the crime in the domestic legislation, to define it as a continuing crime, to define it well and clarify when is the relevant moment for the crime to end. But then on the top of that, also to think of situations which are not so straightforward, so crystal clear. For example, I'll just give you 2 examples, and with it I finish. I'm afraid of the moderator. There are some cases, for instance, in Spain, where even the forensic have confirmed that it's objectively impossible to determine the identity of the mortal remains. Well, because I'm not a forensic expert, maybe there is one in the room who can confirm this, but in my understanding, sometimes really the humidity of the soil prevent from this. There are some cases, and we had one in Switzerland last year, next panel will say more about it, where there was a situation where a country was, of course, would block if we would want to objectively enter the country and exhume the mortal remains to verify if what perpetrator was saying was correct. There are many cases, and this was stressed in this panel today in the morning by the victim representative from Uruguay, where you cannot verify the mortal remains of the whereabouts because simply all the relatives of the disappeared have already passed away. And those are difficult questions. I leave you with that, and I thank you for your attention.
Thank you very much, Anna. So we're going to change panels now for the second part of this presentation, and I will turn it over to my colleague Sandra EPAL-RATJEN for moderation. Thank you all.
Thank you very much, Ian. Good afternoon, everyone. My name is Sandra EPAL-RATJEN, and I'm also with the International Commission of Jurists. I'm the International Advocacy Director. We were told that we unfortunately don't have really a margin of maneuver with the time, so we will have to close as planned at 3:30. So time is of the essence, and so I will be very brief. But just to say that the second part of the panel is aimed at opening up to new and emerging issues, but really based on what we just heard from the first part of the panel. And so I'm really pleased to take over from my colleague and continue the discussion on the basis of what we heard, including in terms of the experiences and the challenges from international tribunals and national courts in ensuring accountability for enforced disappearances. And to continue this discussion, we also have a brilliant panel with us. And the first speaker will be Robert Petit, who is head of the International Impartial and Independent Mechanism for Syria, so the IIIM. Mr. Petit led the UN follow-on mechanism on the DRC in relation to the murders of 2 members of the group of experts back in March 2017. He served as senior counsel and team leader in the Crimes Against Humanity and War Crimes section of Justice in Canada. International co-prosecutor of the extraordinary chambers in the courts of Cambodia, and a number of other positions. In the interest of time, I will not mention, but a lot of experience, obviously, from you, Robert. And you will now give us a short presentation on the experience of the mechanism of the IIIM in investigating enforced disappearances, including, obviously, challenges, but also maybe solution. And I cannot but not mention the fact that Syria is obviously a very topical situation to look at today. So the floor is yours. You have 10 minutes.
Thank you. The last part being important, 10 minutes. Indeed, Syria is probably one of the worst cases of enforced disappearance. Syrian civil society is still trying to document the tens of thousands have disappeared over the years under the regime, and at least the number 150,000 is probably the low end of the figure. So it's one of the worst crimes, and as been mentioned before, one of the worst in terms of impact for victims, for loved ones who for years and sometimes generation until their death don't know what happened to their loved ones. About the IIIM itself, the IIIM is a very novel, unique way of addressing lack of accountability, impunity. It was created by a General Assembly resolution in 2016, in December 2016, because at the time, for 5 years, the regime and its allied and other forces had been committing serious international crimes in Syria in total impunity. And there was no way to refer the situation to the ICC or no justice in Syria. So the General Assembly created the IIIM. It's not a court, it's not a prosecutor's office, it doesn't have a specific jurisdiction. What it does is have the mandate to gather, collect, preserve, consolidate evidence, and analyze that evidence, the evidence of commission of those serious violations, and do 2 things. Support current jurisdictions, and we've been able to indeed support over 300 separate investigations and prosecutions all over the world in 16 different jurisdictions by feeding them evidence, interviews, witnesses, analysis, that sort of thing. And also our second part of our mandate is to prepare for future accountability for Syria, which now at least is no longer a dream, but a possibility as of the 8th of December. And we've been doing that. So as part of our process, we of course develop cases, our own cases, depending on, I have to say that our mandate is for crimes committed in Syria from March 2011, regardless of the group of perpetrators and regardless of the group of victims. And it's an open-ended mandate. So we have been preparing as well specific cases on different types of crimes and different groups of perpetrators. Perhaps for the sake of timing, I will refer to one particular case in which the IIIM was able to assist. And I should mention that our assistance to jurisdictions is confidential. So we can only talk about the cases which we assisted if that jurisdiction gives us permission. One of those cases, an enforced disappearance case, is in France. It's the case of Maji Nema, aka Islam Alouche, who was initially charged for acts of torture and attacks against the civilian population, and also specifically the enforced disappearance of 4 human rights defenders, Razan Zaitouneh, Wael Amada, Zamira Al-Khalil, and Nazim Al-Madi, human rights lawyers who were kidnapped by his group and never seen again. Following a complaint supported by, among other things, the FEIDH and other groups, the French judicial authorities opened an investigation against Alouche and I should say Nema, and eventually brought charges in 2023. And he was charged with complicity in war crimes, complicity in enforced disappearances, and participation in a group formed for the preparation and commission of war crimes. The charges, however, of complicity in forced disappearance were dismissed. Because of French law, the judges in the Court of Appeal determined that to be charged and to be found guilty, an individual had to be either a representative of a state or associated with a state. So a difference in terms of the Rome Statute definition, which also refers to state, but also to political parties. That difference, unfortunately, led to his acquittal on that particular case. That is one way we contributed to the case with, again, as I said, witness statements, different pieces of evidence, and also an analytical report. The case now is scheduled for May in Paris and is for complicity in war crimes, more specifically the recruitment of children and participation in a group that was formed for the purpose of preparing for war crimes. The way we are continuing to address various crimes that have been committed in Syria is to obviously continue to support by current jurisdiction, preparing for this future accountability. And we also are supporting the work of missing person institutions, more specifically the newly created IIMP, which was created last year, again, by a resolution of the General Assembly. And we have been supporting the work of the IIMP and look forward to a very close relationship. We have evidence. We have certainly lessons learned in terms of managing data. It's probably the biggest challenge in these cases is the amount of data and how to sift through it to get answers. We will certainly assist with that. And we're also hoping eventually to get the permission to go back to Syria. I was there in Damascus in December, right after the fall. We're hoping to be able to go and to set up a permanent, or at least a stable, sustainable office there to try and work and answer in part, one of the most important crimes that has happened to Syrians since at least March 2011. Thank you.
Thank you so much, and for also being very, very concise, and hopefully we will be able to take a couple of questions and comments from the floor after that. But yeah, thank you for highlighting the investigation and identification of perpetrators that the mechanism is doing, and that shall serve justice, including under universal jurisdiction. And that's something that leads me to our next speaker, Ilya Nusov, next to me, who is an international lawyer and the acting head of International Justice Desk of FIDH. He was a researcher previously and teaching assistant at the Geneva Academy of International Humanitarian Law and Human Rights Law, and prior to that, again, a legal advisor at the International Center for Transitional Justice. And indeed, as I mentioned, Ilya, you will actually talk to us about a very real experience in a very real case, obviously, and show the challenges and well, possible solutions to address them. And this is the case of Yuri Arovsky, a Belarusian hit squad member, trying to hold him accountable for enforced disappearances and murder in Swiss courts on the basis of universal jurisdiction. And yes, we'll look forward to hear you on the challenges that practitioners face. Thank you.
Thank you very much, Sandra. I'll try to be as concise as Robert, but I think it might be very difficult. Before I begin, I'd like to say that I'm speaking on behalf of FIDH, but also on behalf of the Global Initiative Against Impunity. It is an EU-funded project to further victim-centered justice, which is civil society-led. It is implemented by a consortium of 9 international non-governmental organizations with FIDH in the lead. There are 2 associate partners, one of which is the ICJ, which is sponsoring this panel. But I will indeed focus on the Arovsky case right here in Switzerland, which was brought by FIDH and its global initiative partner, Trial International, as well as the FIDH member organization in Belarus called Vesna. One of the first universal jurisdiction cases targeting only enforced disappearances, and the very first one in Switzerland. We hope it's one of many to come, because I do see extraterritorial jurisdiction and universal jurisdiction as the emerging sort of, as a more viable avenue of accountability for the crime of enforced disappearance, which is going to gain prominence. And the reason for that is, I think, in the very nature of the crime of enforced disappearances, due to which there are very limited avenues of accountability to prosecute this crime domestically and internationally. And that's because some of the things that have been mentioned already, namely the secretive nature of the crime, the fact that law enforcement authorities are often involved or complicit, or the crime is committed with their acquiescence, which is why there is a lack of political will to prosecute these crimes domestically. And to ratify the convention. But even at the international level, we've heard the deputy prosecutor mention that it is challenging to prosecute enforced disappearances in the International Criminal Court, because it could only be prosecuted as a crime against humanity. So you need to meet these contextual elements of widespread and systematic, which sometimes are not present. So it cannot be prosecuted as a standalone crime, especially in peacetime. And so for these reasons, domestic courts with extraterritorial jurisdiction are oftentimes the only jurisdiction that's available to try this heinous crime. And such is the situation that we faced in Belarus, which will not investigate or prosecute any serious human rights violations, is not a party to the ICC. Even if the ICC had jurisdiction, then at the time it would be difficult to argue that at the time there were widespread and systematic human rights violations amounting to crimes against humanity were taking place. So we faced a lot of challenges bringing this case in Switzerland. Just by way of background, the case stems from enforced disappearances that took place in the 1990s and 1999, to be specific, and involved the disappearance of 3 extremely influential Belarusian opposition figures, Yuri Zakharenko, Viktor Konchar, and Anatoly Krasovsky. Belarus has never conducted an effective investigation or revealed the whereabouts of victims. In 2019, Harovsky gave an interview to Deutsche Welle, which was pointed out to us by our member organization, where he confessed to his involvement in the kidnapping and what he alleged was what he claimed was the murder of these 3 individuals. He said that he was in the car when the abduction took place, and he actually saw his superior, the commander called Dmitry Pavlichenko, who is this really odious character who's still running around Belarus, he was involved heavily in the suppression of the peaceful protest in 2020. And based on this information, our partners at trial conducted an investigation to determine his whereabouts, and we located him in the canton of St. Gallen in Switzerland. And then the 3 organizations, Trial International, FIDH, and Vesna, with representing victims, the families of the disappeared, brought complaints to the canton of St. Gallen, substantiating that crime. It's important to say that the first testimony Harovsky provided was during asylum proceedings, which is something that will figure in the judgment of the Swiss court, to which I'll refer to, which I explain right now. Unfortunately, he was acquitted in September 2023, finding that Harovsky's testimony during the asylum proceedings and the testimony he provided during the trial contained some discrepancies, making his testimony not credible enough to prove his guilt beyond a reasonable doubt. And his testimony was the only basis, basically, of the factual findings. And the court also raised a number of legal issues in the judgment. So now I'll get to the actual challenges that we face, which I think are common to most universal jurisdiction cases. So I'll share a few insights, but the appeal is still pending in the case, so I can't go into too much detail. The first is the capacity issues, and I'm referring here to the lack of specialized prosecutorial units, the lack of judges or prosecutors trained in international law, and even issues such as interpretation of witnesses. Of course, in other jurisdictions, you have issues with forensics and so on. In our case, there seemed that the prosecutors were enthusiastic about the case, but for some reason they didn't conduct, at least to our knowledge, a sufficient separate investigation and only relied on evidence that was provided to them by the NGOs. And very tellingly, the prosecutors did not join our appeal from the decision of the trial chamber in 23. The judges, in our view, displayed a very limited understanding of what enforced disappearances are, and their reading of domestic law was not informed by international law. So, for instance, they ruled that the immediate killing of the victim, as alleged by Horovsky, cannot be considered a deprivation of liberty within the meaning of the Swiss enforced disappearances law. And we believe that this is contrary to the prevalent interpretation of deprivation of liberty. And apparently even the Swiss interpretation, which had submitted to the Committee on Enforced Disappearances at some point. Another disappointing fact was that the judges did not give the floor to the victims. And family members are indeed victims of enforced disappearances during these proceedings, which is important, as we heard today from some of the earlier interventions. The translation was mediocre at best and was only offered to Horovsky himself from Swiss German into Russian when he was directly addressed. In other words, he couldn't really follow the proceedings themselves. And we believe that the poor translation might have accounted for some of the discrepancies in his testimony during the trial and during the asylum proceedings and the previous testimony he provided to the prosecutors. The second issue that we faced is the inadequate implementing legislation, something that Anna has already referred to. So even if the judges are adequately trained, sometimes they will be bound by the poor implementing legislation. For instance, unlike the definition of enforced disappearances, the Swiss law, Article 185 of the Penal Code, requires the intention to remove a person from the protection of the law for a prolonged period of time. That's similar language to the Rome Statute provision on crimes against humanity, which, as the deputy prosecutor said, was presented a separate challenge. The judges, perhaps rightly so, given the legal constraints, they were faced with question whether the intention of Horovsky to murder the victim actually negate that subjective element of intention to remove from the protection of the law. Unfortunately, they answered in the affirmative to that question. There are other procedural jurisdictional challenges, and well, I won't focus on that here. Anna, I think, covered that sufficiently in her presentation, but we didn't have the retroactivity problem because the judges actually agreed with us, despite the fact that it was raised by the defense. They agreed with us that this was a non-issue since the whereabouts of victims is still unknown, and and Horovsky made his revelation in 2019 after Switzerland has ratified the convention. The fourth challenge, access and cooperation. This is common to many universal jurisdiction cases, as universal jurisdiction cases occur by definition outside of the locus of the crime, making the search and the collection of evidence very difficult. And especially in the situation in Belarus, where there's absolutely no access to international prosecutors, observers, and so on, and Belarus has no interest whatsoever in investigating the crime. This challenge here was compounded by the passage of time since the crimes occurred, 1999, and making the search for eyewitnesses even outside Belarus extremely difficult. I will submit that this problem is exacerbated with a crime like enforced disappearances, which involves cross-border acts, where the act commences in one state, then the victim is transferred to a second state, and the prosecution takes place in the third state. And then finally, and I would be remiss if I didn't mention that, but of course the lack of resources of NGOs that work on these issues and try to prosecute these crimes is a challenge for us. With the appeal pending and the Swiss system requiring that the petitioners bear the costs of the appeal, we face basically the prospect of either letting the appeal go or proceeding with a great risk and without having the resources to pay in case those risks materialize. So I have a number of recommendations. If I have time to just rattle them off very quickly, they address all of these challenges, basically that more resources should be allocated to prosecutorial units with jurisdiction over international crimes, the training of judges and lawyers in international and prosecutors in international law, more funding for NGOs that work on these issues. Obviously, the ratification and implementation of the Enforced Disappearance Treaty and the upcoming, what we hope is the Crimes Against Humanity Treaty, which will also include that crime, and their implementation in line with those treaty provisions. And I think I'll stop here. Thank you very much.
Thank you so much, Ilya, also because you did part of the job of the wrapping up, so I will save some time at the end of the panel. But thank you so much for this very concrete example that illustrates and resonate with some of what Anna said, and I may give you the floor, and again at the end, if you want to respond to some of it or comment, but also to highlight the issues with the different definitions of enforced disappearances, including in the Rome statutes. And this is a perfect transition to our next and last speaker on this panel, which is my colleague Kate Vignes-Warren, who is with us with the International Commission of Jurists, or Director for a Global Accountability Initiative. Kate has over 20 years of experience working in human rights and international crimes cases, including as a prosecutor at the International Criminal Tribunal for the former Yugoslavia. And I will stop there, but Kate will, in terms of the bio, but Kate will discuss ongoing efforts to strengthen accountability for enforced disappearances, including by looking at recent and future international law developments with the conclusion of the Ljubljana, the Hague Convention on International Cooperation in relation to international crimes, but also the development of a future Crimes Against Humanity treaty. And I stop here and give the floor to Kate.
Thank you very much. I have the advantage and disadvantage of being the last speaker, and I don't have much time, so I'm going to try to keep it quite short. I wanted to talk about 4 separate initiatives which aim to develop or strengthen international law and standards or institutional structures which will have bearing on the investigation and prosecution or otherwise accountability for enforced disappearances. So the first is the Crimes Against Humanity Convention, or the Draft Convention. The UN General Assembly's 6th Committee and the Assembly took a decision in November to move draft articles on crimes against humanity that had been developed by the International Law Commission from 2013 to 2019 to a negotiating process between states. That negotiating process will now commence and will last until 2029, so it will be another 4 years before we actually have a convention. The important thing, and the main point I wanted to make about this convention is that currently it uses Rome Statute definitions of crimes against humanity. So all of the underlying acts are defined as per the Rome Statute, which means presently that the draft articles contains the additional element required under the Rome Statute that Deputy Prosecutor Khan talked about. So this could, if it remains in the convention, not only lead to a more restrictive development of the definition of enforced disappearances, but make it harder to investigate and prosecute if applied in this way domestically. So it's very important in the negotiating process, and it's something that civil society organisations are already raising, to ensure that they amend that definition to be consistent with the international convention definition, so removing that additional intent requirement. Two other important points about that convention. It includes presently the principle of aut dedere aut judicare, so the obligation to prosecute or extradite where an extradition request has been received, which is hugely important. And on gender, and just reflecting on Prosecutor Khan's input on gender earlier, the definition of gender under the Rome Statute has been taken out after significant lobbying by civil society to do so. It's still an open question as to whether or not a definition will be put back in, and it is affecting negotiations at the moment, with some states concerned about a more expansive definition being applied. One thing that this convention will obviously not do is facilitate the investigation and prosecution of enforced disappearances that don't constitute crimes against humanity. So as Ilya was referring to, standalone acts of enforced disappearance that cannot be found to be part of an attack on a civilian population. The Ljubljana-Hague Convention on International Cooperation in the investigation and prosecution of genocide, crimes against humanity, war crimes and other international crimes can facilitate investigations and prosecutions to the extent that they enable better cooperation between criminal justice authorities who are addressing these crimes. Currently, this convention has only 37 states parties, so it was only enacted last year, and so there are a limited number of ratifying states presently, and it's important to continue to press states to ratify it. What this convention allows is a treaty basis for states to cooperate with each other in investigations and prosecutions of all of these crimes, including enforced disappearances as a standalone crime, based on the International Convention definition. So it doesn't rely on the Rome Statute definition for standalone enforced disappearance. It relies on the Convention definition, so it's more progressive in that respect. It also allows for mutual legal assistance, extradition, transfer of sentenced persons, and importantly, the protection of victims. Two other points quickly. The other one that you might not know about because it's not widely published is the Council of Europe is considering reviewing its guidelines and eradicating impunity for serious human rights violations. Although these are non-binding, they are influential. Currently, that does not apply directly to enforced disappearances. It only applies to a range of other rights under the European Convention on Human Rights, including the right to respect for private and family life, the prohibition on torture and inhumane or degrading treatment or punishment, and the right to life. Currently, discussions are ongoing around the expansion of the scope of those guidelines to include all international crimes, crimes against humanity, war crimes, and genocide, as well as standalone crimes under international law, including enforced disappearances. So it will be important, again, if that is included, to ensure an expansive definition of enforced disappearances consistent with the International Convention, and ensure there are strong provisions in there ensuring access to remedies and reparations. And finally, with I think 1 minute that I have, in terms of institutional reforms, the OHCHR, under the leadership of the High Commissioner Volker Turk, is currently going through a process of restructuring some of the units that are presently responsible for facilitating or carrying out or supporting UN-mandated investigations and inquiries, bringing their investigation support unit and their data management units under one umbrella and adding a judicial cooperation section, which aims to support criminal justice authorities' requests for access to information and evidence when it's conducting investigations or prosecutions. It's still very early days and they still need a fuller budget to be able to do that and staffing. But it is an important initiative that can facilitate more effective and efficient work by the UN to support investigations into enforced disappearances and support subsequent prosecutions. Thank you.
Thank you so much, Kate. And I'm turning to, I think we need, unfortunately, to close sharp now, or do we have time for one question? One or two? Okay, so I get the, yeah, I see some hands, but I'll try to dispatch them. So we have the gentleman here and then maybe a gentleman in the back. Yeah, here and then back. And unfortunately, I think we'll take only two and conversation will go on over a coffee break. Please. And keep, sorry, if as much as possible, keep your comment or question short. Thank you.
Thank you so much. Can you hear me? Can you hear me? No? Thank you so much. Perhaps this question is for Reid and also when we're speaking about impunity, when it comes to African states, the question that they raise is that this international, yeah? Okay, I'll do that. So what they raise is that these international systems, or the ICC or others, are primarily some form of neo-colonial, and we heard that a lot with the former president of Sudan, for example. So what are the other mechanisms, or what's the response to that narrative that comes from? I don't know if my question is clear for you.
Test.
Okay.
Okay, thank you. And I think this will be for Reid afterwards, but then maybe, if that's fine, we go directly to the gentleman there in the back, and then we get back to the panel, and then we will have, unfortunately, to close already. I'm sorry.
Thank you.
Sorry for that.
Thank you very much. I'm lucky Reid came on the desk. So first I want to appreciate his struggle and commitment, how he did a long struggle. So my question has got two parts. First is from Reid's, and then second is from the rest of the panel. I come from Balochistan, and in Balochistan, thousands of people are missing. And I would not go in detail, just I wanted Reid to compare it with the rest of the world. Recently, last week, in only 4 days, above 50 people were abducted in different areas of Balochistan. And day before yesterday, a person was planted with a bomb and he was detonated. He was a missing person, and later on, this happened with him. And it was very simple. He was planting a bomb and he was killed. Very simple. Family was witnessed. In front of them, he was abducted. Even when he was abducted, his family came to the press club and they did a press conference. Last day, he was abducted. So my question is, how do you compare? Do you see such atrocities in the rest of the world also? In your struggle, have you seen? And my second question is from the panel. What are the possibilities to bring these criminals, or whatever you call them, to justice? Because the voice of people does not come out. They are silenced. No, for example, this one family member of the person was abducted and it was done like that. So it would be difficult for the rest of the family members to come and raise their voice. Thank you very much.
Thank you so much. So I give immediately the floor to Reid, and then on the second part of the question, we'll see if the panel wants.
Thank you. I think both of your questions relate to, I think, what is the Achilles heel of international justice, which is double standards. Until this November, when the warrants were issued against Benjamin Netanyahu and Yoav Gallant, the International Criminal Court had never sought a warrant against a Western ally. In fact, since Nuremberg, I think none of the instruments of international justice in fact, they've always been targeted towards either defeated adversaries, as in Nuremberg and Tokyo, against powerless, African, warlords or ex-leaders, or against enemies of the West, like Vladimir Putin and Slobodan Milosevic. Not always. I mean, we have Kosovo, and we have, but to a large extent. I mean, right now we're living, a turning point in international justice, because the fact that the ICC issued these warrants may be the end of the ICC. I mean, we are now looking at American sanctions. I mean, those of us who were in The Hague a few weeks ago at the ASP, I mean, people are freaking out. And we see sanctions coming against the ICC and against people who work at the ICC. And I think we have to ask, I mean, will the fact that the ICC has for the first time shown that international justice can be even-handed, will that be, will international law die in the rubble of Gaza? Or will people here and people from Baluchistan and people from Africa and like-minded countries around the world rise up and defend international justice at this key moment so that it rises from the ashes of Gaza? I think we're at a really critical moment in the world of international justice.
Thank you for this call for principles stand to in favor of international law. And I don't know, Anna, if you want to close by a couple of minutes comments, as I promised to go back to you. But really, this is about the wrapping up of the panel. So happy to leave you the floor.
Anna? Well, I'll devote some words to your question, and then I'll try to close. I think it's that moment when also students in class ask you this question, oh, but you told us prohibition of force, it's prohibited, and then, the next day there is a bombarding in another state. And you try to explain how is this possible. I mean, it's a difficult question. Evidently the first, I would say the first requirement for criminal accountability to happen is the will to carry out criminal investigations. But at the same time, let's not forget that the reason why we are here today is advocacy, was actually the efforts of the families who, despite of the states denying that their loved one went disappeared, which were saying, you're crazy, that's not true, you don't have your loved one went away with their lover, what were the excuses, the families were insisting to bring this to international agenda. And here we are today, and we've achieved, I think, a lot in the past decades. And I think something that you can do is really running through this international regional advocacy as well, which in my knowledge, at least you've been already very actively doing, and it's often through registering cases to different human rights mechanisms, which are then pressuring the country, and in some cases it actually does help. And this kind of systematic, if you like, human rights violations that you've been mentioning, they do happen worldwide. They happen, I would say, in different modalities nowadays. But unfortunately, they do happen worldwide. What I do think is that it's just really, really important is that you are aware that you can achieve a lot also through the different international regional forums. With this, perhaps I would close just by saying that the reason why I actually started to work on the crime of forced disappearances was because I previously worked more in the human rights, humanitarian question. But I always felt, even with the families, that they felt we are not devoting sufficient time to the criminal accountability, and it actually did matter for them. It's not about either the search or the investigations, it's about both. They are both parallel obligations and rights, I think, of the families. So perhaps I'll just close with a statement saying, I'll say it first in Spanish, Donde están importa, pero quien lo hizo también. Where they are matters, but who did it as well. Thank you.
Thank you very much. And with that, we close again. I had a list of takeaways, but I think, Ilya, you systematized them pretty well. And our conversation, I think, gave a lot of the challenges, but then also the path to improve the system for more accountability for enforced disappearances. So thank you so much for your attention and for being so numerous with us today. Thank you.